really, often to look to the young ones to make presentations, but to drag out one of the old ones like me to talk about the historical background to where we've got to now. And back in 1983, when I was young, and it's kind of hard to imagine I was ever young, but I was back at that time, I heard from some conference that was going to be held in Jerusalem, organized by the wonderful Dov Kalani, Al Analik, and Hossi Fossman, who went on actually to found our organization. I applied in the university that I worked in to go to that conference, and we had a vice principal at the time who was not the most charming of human beings. And he sent for me, and he called me Sonny, by the way. In Scotland, Sonny can be a term of endearment, or it can be a patronizing term. You can imagine which one he used. And he said, listen here, Sonny, what's this subject called tourism law? It sounds Mickey Mouse as a subject to me, he said. Prove to me it's something more important. So I went and did my research. My university was a new university. So I went to Aberdeen, which is from 1460 and so on. And they have an incredible library of medieval texts and so on. And I dove through them expecting to find nothing. And I found the first work I found was from 1465, saying this edict, this Roman edict on liability of shipmasters, innkeepers, and stable keepers was too out of date, you know, because it'd been there for a few hundred years. Imagine in 1400 finding a criticism and imposing strict liability was really unfair to those businesses. So I was amazed at that, and I went on to read some anthropology and whatever, and to discover that travel law, maybe not tourism law, but travel law has been there a long time. Now that Roman law edict is still around. I'm in the Maldives, and I'm drafting tourism law, substantial tourism law amongst other things. And I asked about which part of the civil code deals with this liability of innkeepers, for example. Every lawyer I met here said, no, we don't have that kind of thing. That sounds very strange. And I said, I'm sure you do. No, 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 no. So I made them troll through the civil code, and there, of course, it is. It's there. And not only is it there, but in the Supreme Court of Mauritius in 2012, there was a challenge against a hotel keeper, a five-star hotel keeper, and they relied on that provision. And the defense said, this is out of date, old-fashioned, this is ridiculous, and it's burdensome. But the Supreme Court of Mauritius upheld the Roman edict, the principle of strict liability of these three parties. A South African lawyer who worked with me said, we don't have it in South Africa. The Supreme Court of South Africa 2010 said, yes, we do, it's still there. So the rights afforded by the edict are not based on any contract or any agreement, they're based on status. By being a traveler, you had that protection. In the 19th century, and as Goretti pointed out, not all travel is tourism, but all tourism involves travel. So in the 19th century, as people began to travel not through necessity, but through pleasure, Mr. Thomas Cook in 1841 with his first excursion to Loughborough and so on, we had what were known in the common law countries as ticket cases, because there was contracts, but you got a ticket. The ticket basically says if we crash the train, if the driver's drunk, whatever happens, we accept no liability whatsoever. And the more moderate of the ticket cases said, well, we accept some liability, but the compensation will be poor. So this was a change almost opposite to what was originally intended under the edict. By the way, England, and I mean England, not Scotland, not the United Kingdom, didn't exist in those days, rejected the Roman edict because they Brexited back in the 12th century. And they said, we have no such thing. But when I read some of the old English jurist works, they had identical provisions, but they said they're nothing to do with Roman law, they're to do with public trust. So it's a public law provision, not a civil law provision for them. What began to happen in the 19th century is the courts began to interfere and began to say freedom of contract is fine if the parties are equal, but where they're not equal, then unfair and unreasonable terms and conditions should be declared null and void. And that began the process of reform in favor of the consumer. Tour operators and travel agents hid behind non-liability for independent contractors. They would say in the 80s and early 90s, we're not liable because we don't employ them. Those services that you've contracted for are provided by people, third parties over which we have no control. That was challenged. Initially, it was challenged by Unidroit. We had the hotel keepers contract, we had the travel contract and so on, but they were not very effective provisions. We had Jarvis v. Swan Tours in the common law country, bringing the concept. Dr. Jose Fossman, our wonderful previous president, attacked it, saying, don't shoot the tour operator. Jarvis v. Swan Tours, of course, establishing the principle that holidays are contracts of enjoyment. If you don't enjoy it, you can claim. The Germans took it further and said, basically, everything that goes wrong, you can claim. So you had the German Travel Act of 1979, followed by Ontario, New South Wales. There was a beginning to see that better protection was needed to be afforded the consumer. All of those protections were status right protections. They involved contractual provisions, but they were implied terms that were not negotiated. They were automatically part of the deal between the consumer and the supplier. Dr. Rifai said about the host countries, and again, most of the work I do is for host receivers of tourism and so on. Don't forget them, don't overburden them, don't take advantage of them, and so on. And the Millennium Development Goals lays down principles about host communities. And I wrote a report for the Dutch aid agency, SNV, about how you apply the Millennium Development Goals to the tourism sector. And I'd happily share them with you in the future. They were replaced by the Sustainable Development Goals. And remember, it's about development. It's not about banning development. Local communities have a right to economic activities, but taking into consideration matters such as climate change. The Global Code of Ethics in Tourism came, I think, about the year 2000. It said many good things, but as lawyers, we were quite critical of it, or should I say John Downes was very critical of it, because it seemed to say nice things. Now, Alicia will no longer appreciate my thank you and so on. But at the time, I thought it said something like, love your mum, be nice to other people, try not to drop litter in the street, almost. And so it had no legal effect. And one of my concerns I have about the new code is that it should have legal effect. I know it's an excellent start, but it's not the finish. I believe this code on the protection of tourists should progress to at least become a convention. But it contains some excellent provisions in it. The other thing is, the idea of when the courts began to intervene in freedom of contract was the inequality of bargaining power. Well, inequality of bargaining power exists between the sending countries, the tour operators from the rich countries, and the small provider of tourism services in the host countries. And we have to re-examine this. And I think, in fact, Maria Goretti raised this at a previous conference. What about protecting the small supplier? B2B contracts need to be looked into on the inequality of bargaining power as well. The work done by UNWTO was excellent work, as I said, but one of the problems is how do we manage to ensure that those provisions work globally? So when I've raised that we should do it, excuse me, in Mauritius, one of the problems in Mauritius, which by the way is not a poor country, is how can you get insolvency protection? None of the banks are interested, none of the insurance companies are interested. They think it's too big a risk for them. And yet, if we adopt the code, we have to cover the insolvency protection. This is true of many small and many poor states. Many of the Caribbean, the 15 Caribbean CARIFORUM states, almost none of them can obtain insolvency protection. So again, we have something that's meant to be global, but which practically doesn't work. I'm not going to take up much of your time. I just wanted to make that general introduction, if you like, to the problem of protection of tourists and the protection of tourism service providers. Thank you.